My name is Bree Lohnberger, and I am the Access to Justice Coordinator and the Director of Create Justice at the College of Law. I'm pleased to welcome you to this panel discussion taking place during the 7th Annual Saskatchewan Access to Justice Week, which was formally recognized by the Honourable Bronwyn Ear, Minister of Justice and Attorney General for Saskatchewan. This week is also marking the 3rd Annual National Access to Justice Week, and we welcome those from outside of Saskatchewan who are joining us today on the live stream. As we gather here today, we acknowledge we are on Treaty 6 territory and homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another. Today's panel is titled Using Data and Design for Action, Next Steps for Family Justice in Saskatchewan. It will include perspectives on how leaders of the justice sector are using data and design methods to foster a collaborative and coordinated approach to improving family justice in Saskatchewan. I would like to thank McKercher LLP for sponsoring our lecture series, which allows the college to continue to present a wide range of informative, educational, and entertaining speakers to the law school community. Kate Crisp is a lawyer in the Saskatoon office and practices exclusively in the area of family law, including assisting clients with division of family property, child and spousal support, parenting matters, and divorce. Kate attended the University of Saskatchewan and received her Bachelor of Laws in 2009. I'd like to invite Kate to bring greetings on behalf of McKercher LLP.
Thank you, Bree. I am happy to be here today on behalf of McKercher, and thank you all for attending to hear our panelists speak today. As Bree mentioned, I do practice in the area of family law, so access to justice is something that is very important to me and my clients. I'm looking forward to hearing what our panelists have to say on this issue and to hear any comments they may have with respect to how recent initiatives in the family law area, including mandatory mediation and the new judicial case conferences, are working to help improve access to justice specifically for family law clients. Thank you for being here today.
Thank you very much, Kate. I am now pleased to turn the mic over to Lionel McNabb, who's the Executive Director of Family Justice Services with the Ministry of Justice, to Moderator panel. Thank you, Lionel.
Thank you. Good afternoon. Welcome, everyone. Again, like I say, I'm Lionel McNabb, Ministry of Justice, and I think I got to chair this panel because I'm the oldest one. That seemed to be it, but we have a fabulous panel today, and I am going to stay out of this as much as I can, so I'm going to just briefly introduce them and then let them do their presentations. We will have questions, but at the end. So just so everyone understands, at the end there'll be questions. So if we could hold off till the end. Diana Lowe will be starting, and she's reforming the family law justice system. Stacy Muller is with the Dispute Resolution Office, the Ministry of Justice. Tiffany Paulsen, KC, Robertson Strongbird and Solicitors, and Chief Justice Martin Popescul, who was kind enough to join us as well. So thank you. Diana is hopefully online. We will hand it over to her.
Thank you for inviting me to speak with you today. I'm one of the co-leads of an initiative in Alberta that's called Reforming the Family Justice System, or RFJS. The RFJS is a multi-sector, multi-year initiative that's aimed at improving outcomes for families who are dealing with family justice issues. It was convened in 2013 by the Court of Queen's Bench of Alberta, now the Court of King's Bench, by the Ministry of Justice and Solicitor General of Alberta, later joined by the Law Society of Alberta, by the Family and Community Support Services in the County of Strathcona, and by Native Counseling Services of Alberta. These are the conveners of the initiative. We actually have hundreds of collaborators engaged in this work from across many different sectors. In the time we have, I won't be able to do too much of the fourth in my goals for today, but I can tell you that we have run a number of pilots and are starting to see many shifts taking place in our family justice system. Mostly what I will talk to you about is the evidence that the initiative was founded on, and I'll show you some of the tools that help us to support this work by continuing to ensure that we have an evidence base as we move forward. I will be very happy to answer questions or to speak with you individually about some of the exciting changes that are underway in Alberta. And I've put together a list of resources that will cover most of what I speak about today. So between Bree and I, we can work out how to make arrangements to get those to you if you're interested. The slide that I put up reflects the kind of very strong statement that is often made about the family justice system. Any of you who work in this field, who have experienced family justice processes personally, or who know others who have been involved in separation, divorce, family violence, or child welfare matters, are probably nodding your heads. And I start here because this helps to underline the urgency for change. In 2013, a number of reports came out from the National Action Committee, which were focused on improving access to justice. This committee was started by Canada's former Chief Justice, Beverley McLachlin, and so was given a lot of attention in jurisdictions across the country. The reports themselves created the opportunity for change, which led to the RFJS in Alberta. There have been a number of reports documenting the problems that the family justice system has been experiencing. And for today, I'm just going to talk about 3 that were published by the National Action Committee. The first came out actually in 2012. It was a commissioned report that looked at a number of different initiatives and reports from Canada and beyond. And one of the really striking comments in the very thorough report is one which says the perception that the various family justice reform efforts made to date have fallen short of the mark is reasonably common, as is the suggestion that something more drastic or fundamental is required to bring the necessary changes to family justice. Similarly, the family report of the Action Committee, which was called Beyond Wise Words, came out in 2013, and at pages 5 to 6 of the report, there's the quote that really underlines the urgency for change in terms of the impact of the existing system on the families that are served. In Alberta, we analyzed the discussion in the Beyond Wise Words report, and what we found is while there were these statements of strong concern about harms for families, so really looking at outcomes, and there were calls for drastic change, the actual recommendations in the report tend to focus on what we already knew in the justice system, which is how to improve the system as it exists. The recommendations focused on things like how to improve the skills of professionals who work in the system, how to ensure better procedures, and to respond to the legal needs and education of the public. This happened again in the roadmap report of the Action Committee, which kind of tied together all of the different reports that were released in 2013, and it was published about 6 months later. In that report, there was a repeat of the call for a new way of thinking, which was referred to as a culture shift, which in systems change work is also referred to as a shift in mental models or a paradigm shift. And so what I can tell you is that the Alberta RFJS initiative has relied on the Action Committee reports to create this opportunity for change that led to the RFJS. But what we did was to focus our attention on the kind of drastic change or paradigm shift that the report called for, not on the specific recommendations for system improvement. So I'm not going to spend a lot of time, although the question of what is a culture shift or a paradigm shift is really pretty fundamental. But I can tell you that some important systems experts have written about this and helped us to understand that a paradigm shift really requires us to open up our minds and imagine what is possible. And that is the kind of thing that we've undertaken for the last 8 years in Alberta. It turns out that paradigm shifts tend to be successful when they're supported by new evidence. Think about campaigns to stop smoking, to make seatbelt use mandatory, to change the environmental impact of our litter with blue boxes. New evidence, most often about harms in these circumstances, were behind all of these kinds of changes, which have now become adopted, but were really big culture shifts at the time. In terms of the family justice paradigm shift, the new evidence that guided our work is brain science. In Alberta, we have the benefit of the Alberta Family Wellness Initiative, which has done extensive research, education, knowledge mobilization, and implementation of brain science into policy and programs across many different sectors. They make available a free online 19-module brain story certification program, and we've actually encouraged all of our collaborators, and especially our justice system participants, to become brain story certified. In fact, the Court of King's Bench has approved the certification as part of its continuing judicial education. I'll just speak to you briefly about brain science, which includes the Adverse Childhood Experiences Studies, or ACEs. From these studies, we know that the impact of ACEs increase exponentially the more adverse childhood experiences a young person has in their life. We see ACEs as directly relevant to family justice issues in this way. Separation and divorce, as you can see here, is one of the 10 ACEs. Abuse, neglect, and other household dysfunction are the 3 categories of ACEs and are really part of the situations arising in child welfare and family violence matters. What we've seen is that the family justice system often exacerbates and even causes toxic stress for children and adults who are involved with it, because it's based on an adversarial model of dispute resolution that encourages a win-lose paradigm of conflict rather than de-escalating conflict and creating conditions for collaborative decision-making. Parents can get caught up in a downward spiral that becomes about winning and losing rather than acting in ways that reduce the stress and support their child's brain development and resilience. Unfortunately, we also see that the removal of children from their family home and the incarceration of a parent are themselves adverse childhood experiences. So what that tells us is that the responses that our systems have had to those kinds of domestic violence situations have actually added to the adverse experiences of children in these families. When we look at the evidence of brain science, it's really no wonder that so many family justice reports have suggested that family justice processes do more harm than good. It aligns with the impressions we all have that children don't do well when their parents are experiencing separation and divorce, but the science really proved what we've all been feeling for a long time. The negative consequences of ACEs include behaviors, physical and mental health issues, including a lifelong risk for serious disease. ACEs can also be transferred intergenerationally through epigenetics, and that is very much aligned with Indigenous knowledge of intergenerational harm. So in spite of the really challenging outcomes that we see in the ACEs studies and that you can read on this slide, there is actually hope in the brain science knowledge. It helps us to know what causes harm and how we can prevent or reduce the harm. And we need to remember that our family justice processes are a human-designed system, so we can, and we say must, bring about fundamental change. The slide in front of you is all about resilience. So brain science is much more than just ACEs and trauma. It includes the science of resilience, which tells us about neuroplasticity, or the ability of the brain to change and adapt as a result of experience. If we take steps to reduce sources of stress, to establish supports, to help build responsive relationships, and to strengthen core life skills, which are the 3 elements in this slide, this is actually helping it to strengthen resilience and improve outcomes. And that's where the hope comes from. These 3 principles to build resilience were established by the Harvard Center on the Developing Child and are important for reshaping policies and programs to ensure that we focus our approach on helping families to achieve healthy outcomes in spite of adverse experiences. This is another slide that's talking about those 3 principles. They're represented here by the Alberta Family Wellness Initiative's resilience scale, which illustrates that we're working to decrease the negative experiences, which often means reducing the role of legal adversarial processes, to provide positive supports for families, which we can do by helping families to gain supports that are available for their social, relationship, parenting, and financial needs, and to strengthen skills and abilities to manage stress, which might mean skills that help to reduce conflict, to improve communication, and to learn better parenting skills. And that's actually represented by the fulcrum, which can move from side to side and help with building resilience. The present family justice system is all about resolving disputes. So it focuses on access to courts and lawyers, on simplifying those processes, and improving time to trial. With the knowledge of brain science, what we understand is that families also need to improve their skills and have positive supports. And we need to build that into our programs and practices. So what we're talking about is a very significant shift. This is our paradigm shift that the brain science really has guided and supported for us in Alberta. The RFJS theory of change was developed through a powerful process that we were able to undertake with many different groups of our collaborators. What we realized as we did this is that most of what families are dealing with in their family situations, whether family restructuring, child welfare, or family violence, is actually about their social needs, their relationships, their parenting needs, and their financial needs, and that there may also be a legal element to all of this. But what the justice system has tended to focus on has always been the legal needs. And what we realized as we went through this analysis is that by giving too much priority and focus to legal responses, we're really not helping families to deal with the other priorities of social relationship, parenting, or financial needs. Indeed, the tools of our legal system often make the situation worse for families. So what we give them are the tools to fight, and then we wonder why they become so caught up in this fighting kind of behavior. What we've realized for the last number of years is that we actually need to untangle the social, relationship, parenting, and financial needs from the legal, and then ensure that families have the skills and supports that they need to address all of those. And that fits with the supports and skills that the resilience scale speaks about. What we're doing with the RFJS is creating a different path for families to ensure that they obtain the kinds of skills and supports that they need outside of legal adversarial processes. We're collaborating with many different sectors to get their assistance in creating these new pathways. And that's our paradigm shift. What we're imagining is a family justice system where families thrive. So how are we doing this? Through brain science and ACEs, the system has a lot of understanding about why we need to do this transformational change, but not nearly as much about how we do it. We know that the work we're doing to transform the family justice system involves shifts in thinking, policy, organizations, programs, and resources, and requires commitment and leadership of a broad collaboration over time. We've been working with a number of facilitators, including Mark Cabaz, who shared this framework that I've got in front of you. It helps us to see that change happens at 3 levels simultaneously. The pink level up at the top is culture. The arrows show that there's movement from left to right, which we visualize as we move from legal adversarial approaches on the left to family wellness on the right. The purple level down at the bottom are the small experiments with new ideas. This is the kind of social lab work that occurs to develop and test new ideas. And then the blue level in the middle is actually the system. This shows that there are many different players who are all aligning their efforts while retaining their own independence. The system is influenced by changes in culture and by the new ideas as they emerge. And together, the culture shift and the niche innovations put pressure on the system to change, resulting in changes to legislation, policy, programs, etc. As we move from left to right, the system becomes reshaped entirely. Systems change is successful when it's aligned around the common outcome that's sought in a theory of change or a theory of transformation. And in this case, that's our goal of improved outcomes for families or helping families thrive. The kind of knowledge that we get from this framework is something that we then build into our next level of strategy, which is to move to action on this kind of work. And we've done that using something that is called strategy mapping. strategy mapping involves a systems approach, looking at the system as a whole rather than piecemeal or projects. It definitely involves collaboration, at least to the extent of co-aligning around the objectives that we share. And strategy maps can also help to ensure that this long-term complex change work can be visualized and realized. A well-designed strategy map improves the odds of succeeding with the kind of large-scale systems change by helping to organize complex collaborations of many different organizations that are involved in different but mutually reinforcing and aligned actions, by managing the details of the short-term actions while allowing everyone to see how that detail fits into the bigger picture, and providing a structure that monitors progress on actions and measures outcomes beyond the efforts of any one organization. So what is a strategy map? It's really a visual representation of an aligned set or system of strategies that is intended to bring about change. A lot of people are familiar with logic models and theories of change, which are just ways of linking aspirations with capacity. And strategy maps are like this, but they are more robust and they're better suited to large transformational change efforts. You'll see that the outcome is aspirational and it's reflected at the very top of the strategy map. It expresses the purpose of the collaboration or the big change that's being sought. The strategies, actions, or measures are all designed to help achieve the outcome. Strategies to achieve outcomes have sub-strategies that are logically connected, so you know that to have X happen, you need to do Y. And the strategy map helps you to make those connections. And then finally, in the capacity development at the bottom of a strategy map, this is about the conditions that you need in place in order to achieve the strategies. You can put a ton of detail into a strategy map, and you can zoom in deeper to look at more detailed levels of the strategy map, but also you can move up, much the way you can move around in Google with a Google map. What I'm showing you now is the Transforming the Family Justice System strategy map, which was developed by Alberta and also by British Columbia. And we created this together in 2020 and 2021. It's actually the second level down from a higher level strategy map that relates to many different sectors that are incorporating ACEs and resilience into their work to achieve better outcomes. Near the top is our outcome objective, which is to transform the family justice system by focusing on achieving family well-being. That relates to our goal of helping families thrive. The three principles for creating resilience, which I've shown you and which were developed by the Harvard Center, are shown here in the outcome strategies of reducing toxic stress, strengthening core life skills, and building support for families. In the outcome strategies, we also recognize the need to integrate this work across many sectors and to look at reducing costs. Moving into the center part of the map, you'll see that we arranged our action strategies into the three categories that were identified in the GEOS framework, the diagram with all of the arrows. So in the left-hand column, you'll see the strategies are focused on achieving a new paradigm shift based in brain science. So there's a lot of talk about creating a new mental model and increasing the understanding about brain science within all of our systems. In the right-hand column, what we see are strategies that are about innovations that will show us new ways of addressing the needs of families. And that's, as we said, really important in order to create transformational change. And then in the center are the broadly defined justice policy and programs. What we know is that systems tend to be very difficult to change, and it's important that we convince people through the mental model shift and also by playing with new ideas of the need for change. And that we can't start just with changing policy or creating new programs if we're really going to bring about a significant change. At the bottom level of our map, we identified the capacity development that will help to create the strong foundation for our work or the necessary conditions. And you can see this is about learning to collaborate. It's about integrating Indigenous processes, working at a level of systems, bringing in a variety of different kinds of resources, and also using developmental and transformational evaluation as we move forward. One of the things that I mentioned is that we can zoom in from the strategy map to look in more detail at some of these strategies. And so as you'll see up in the strategy around increasing the family justice sector education and brain science, there's a little plus sign here. If we click on the plus sign, it will actually take us into a deeper level of strategy. Here in this example, we've identified 3 groups of justice system participants that we work with on brain science. And with each of these, you need separate strategies because you're going to work with different groups. So when we're talking about law students, we're thinking about education through law schools, working with professors, curriculum committees, those sorts of things. With judicial education, we're talking about the National Judicial Institute and individual courts, and at continuing legal education organizations with the Law Society and Bar Associations and continuing legal education. From here, we can actually move into a strategy engagement platform that was developed by our partners at Insight Formation. And these are the people down in the States that we've been working with and who have introduced us to the strategy mapping approach. With this strategy mapping platform, we can develop appropriate measures and targets and actions relating to deeper strategy objectives, and we can continue to measure as we move forward. I'm just going to go really quickly through this so you get a sense of the kinds of tools that are available. Within the platform, you can see that there can be details with a description about each objective on the strategy map. And here I've just used the same example. And this is a visual from the strategy platform. From here, we could go back up to the strategy map, or we can keep going. And in this case, I'm just going to move forward into the from to gap, where when you look at this, these are statements that are straightforward and intentional ways of describing the kind of change that we're trying to achieve by articulating both what our current state is, that all shows up in the column on the left, and the desired state column on the right. And we've done this for a number of our strategies, and we continue to do this with our collaborators so that they can really engage with this and start to think about the kind of change that they need to be involved in. Michael Quinn-Patton is a world-renowned expert in transformational change and developmental evaluation, and he has shared with us the importance of using this kind of qualitative, descriptive, and exploratory approach when you're trying to go about transformational change. At the bottom of this page, you can see that there's a reference to measures, and so I'm just going to click to one of the measures sheets where you can see that the tool actually allows you to show progress on the measure, which in this case was the percentage of lawyers who were brain story certified. We can look at historically what the levels are, and then we can set for ourselves what our targets are and measure whether we're meeting those targets, where of course the green means we're on target, yellow means we're getting there, and you can just barely see there's a red line at the bottom here. If we were scrolling down, if this was a live shot of the tool, we would see that in some of the early years we weren't quite there yet. The Insight Vision tool also tracks actions. Everywhere there's a red icon, that's an action. And tracking actions is important because there's so many different actions that are going on when you're doing this kind of work by many different organizations and individuals. And so in this particular example, I created this for the purpose of being able to demonstrate this. And I put in the name Jane Morley, who's one of our collaborators in British Columbia. And not only did I use her name in here, but I had to put her contact information in. And as soon as I saved this, Jane got a message thanking her for agreeing to take on this piece of work, which was kind of neat. That's the sort of thing that the tool does. And then the final piece is just a scorecard that rolls all of the details in the screens that I was showing you together so you can see it at a glance. There's much more I could tell you about that, but I'm way short of time. And so I'm just going to move on to talk briefly about whether we're confident that this is needed and that changes are taking place. So as I started off saying, we know from descriptions of the system from the Action Committee and other places that there are concerns that the system does more harm than good for families. As we engage with our collaborators across many different sectors, what we hear from people is this enthusiasm when they're yelling and saying, that's it, that's what we need to do. We need to help families to thrive. We've also seen research by Professor Trevor Farrow at Osgoode Hall, where they reached out to the public to ask how the public would define justice and access to justice. And what they got was not the typical justice system responses, but a response that was really about the right to a good life. And we see that as very much the same thing as our helping families thrive. The evidence of brain science really for us has underlined and supported the change that we've undertaken. And so it has helped to confirm the need for us. I'm just going to mention to you that there's an article that has been published by leaders in the systems change world. They're not as familiar with family justice, but they are familiar with how you go about making change. And this has been published in the Journal of Change Management and includes a case study of the work of the RFJS and BC's parallel initiative with us. And the authors of the article also took part in a 2021 webinar with Jane Morley and myself, which talks about the case study and transformational change more broadly. And I'll include the link to that webinar as well as to the article in the materials that I provide to Bree. So that's just a really quick review of work that's been underway in Alberta for the last 8 years. I'm going to stop here though. I'm sorry I've gone over. We're going to have time for questions later, and I certainly welcome any of your questions. And I'll just close by thanking you all.
Good. Thank you, Diana, and I'm sure we'll have questions later. So now we'll move on to Chief Justice Popescul. Will tell us about the launch of their new judicial case system.
Thank you very much, Lionel. I would like to, first of all, thank the College of Law for inviting me to present to you today on the new Judicial Case Conference, or JCC, process for family law matters. I think that the comments that I'm about to provide to you integrate nicely with Ms. Lowe's presentation that we've just heard. Earlier this month, the court issued Family Practice Directive number 7, which introduces a new mandatory JCC process for most family law applications brought in the judicial centers of Regina and Saskatoon, beginning on November 1st of 2022. The directive and the forms can be found on the court's website. I'm genuinely very excited about this truly innovative program. It has the potential to be a real game changer in the ever-elusive quest to improve access to justice. Our court strives to be as innovative as possible in order to improve efficiency and access to justice while still providing justice to the people that come before us. Many institutions and organizations, and there's been many papers written about access to justice. The Court of King's Bench is determined to convert words into action. In the fall of 2019, a few of our family division judges and I went to Nova Scotia to examine up close and personal the family justice model that had been developed in that province. While not all aspects of what we saw there would work in this province, there were a number of innovative, interesting, and worthwhile features that we thought could and should be implemented. A family law innovation subcommittee was struck to follow up on what we had learned and to develop a new model for our province. The members of the subcommittee have worked very hard to implement the JCC enhancement to the family law system. These changes should make our system much better, and of course, that is our goal. I would be remiss if I did not mention that although the impetus came from the judges of our court, it could not have come together without the support, both financially and institutionally, of both the federal and provincial governments, and for that I am truly grateful. So the question that might be on your mind is, what did we discover and what are we about to implement on November 1st? As some of you know, chambers refers to a courtroom where a judge hears multiple applications consecutively. Under the current family justice model, Family Chambers is heard each week in Saskatoon and Regina, every Wednesday and Friday at 10 o'clock a.m. The lawyers and the parties must attend court at 10 a.m. and wait until their matter is called. The current model permits lawyers or self-represented parties to file and schedule an application on any of the designated chambers dates of their choice. Parties must also serve and file affidavit evidence along with their applications. The types of issues raised in these family law applications can vary widely. For example, an application might pertain to interim parenting, child support payments, an application for the other party to file financial information, to name a few. This rudimentary process of having the lawyers populate a list and then have a judge come in and deal with each application on that list one by one has been in existence for decades. But the question became, can this process be improved? The subcommittee identified a number of concerns with the current family chambers process. Broadly, these areas of concern are, number one, family wellness and harm reduction, number two, access to justice, and number three, efficiency in the court system. First, in relation to family wellness and harm reduction, the current process requires parties to file and serve affidavit material that often entrenches positions, increases defensiveness, and fuels conflict for years to come. A justice system that unnecessarily exacerbates family conflict in this manner can compound trauma, particularly for families with a history of interpersonal violence. It can also delay resolution, deplete family resources, and increase stress on children. The JCC will provide an early opportunity for parties, with the assistance of a judge, to discuss ways in which some or all of these issues may be resolved other than by further litigation. This may involve discussing areas of consensus, options for settlement, and identifying the issues that are truly in dispute. By having these discussions before affidavit material is filed, which often contains allegations that increase conflict and prolong the time and cost to resolve legal issues, a judge might be able to narrow the issues in dispute. This will serve to reduce conflict and decrease the complexity of further litigation, thereby saving both time and expense. The second area of concern is access to justice. There are limited opportunities for parties to obtain direction or input from the court on procedural or management issues without filing lengthy materials or substantive applications, which can be extremely costly. For example, the JCC judge may order the disclosure of certain documents before a matter proceeds to chambers. This will expedite the resolution of procedural issues, thereby decreasing the cost to the litigants. Additionally, some parties tend to bring applications that are non-legal in nature. When faced with issues relating to mental health, miscommunication, family conflict, or substance abuse, parties sometimes bring applications to the court in an attempt to obtain legal advice or assistance because it may seem to them that this is their only, quote, free, unquote, option to get a resolution or assistance. A judge may be able to identify very early on in the process non-legal issues that are impacting resolution and refer parties to the family screening officer, who will be able to provide information or referrals to address these non-legal issues. Third, there are concerns about the efficiency of the current chambers model. Parties and lawyers currently have unrestricted direct access to chambers. A party can place an application on the list at any time. The court has no control whatsoever as to how many matters go on this list on any given day. This can lead to some very long chambers lists, which can result in lawyers waiting for hours for their matter to be called, thereby increasing the cost to the parties. Chambers applications are rarely ruled upon at the first Chambers hearing. Adjournments are frequent, which increases the associated costs and the length of time required to resolve an issue. The JCC process will reduce the need to adjourn matters by ensuring that only matters that are ready to proceed are scheduled for Chambers. Further, the Chambers list will be managed by the court. Matters will be placed on a Chambers list by the court based upon urgency and readiness to proceed. This will assist both the court and litigants by ensuring that the number of matters on each Chambers list is manageable, thereby limiting the length of time that the lawyers and parties have to wait before their matter is called. It will also reduce the number of reserved judgments on any given Chambers day, which should expedite the delivery of decisions. So, what is the JCC process? The cornerstone of the JCC model is to engage in triage and judicial case management before a court application is served and filed, with the goal of limiting the number of matters that become litigious. As mentioned before, Family Practice Directive Number 7 establishes the process for JCCs. Participation in a JCC will be mandatory for most family law applications brought under the family rules in Regina and Saskatoon. However, certain applications are exempt from the JCC process, and those are set out in the Practice Directive. I do not intend to, in the time that I have, delve into the full detail about the specifics of the JCC process. However, broadly speaking, the process will be as follows. Step 1, a party will serve and file a request for JCC identifying the relief sought. A joint request can be filed by multiple parties if the parties agree that the court intervention is required. Step 2, a judge will review the request with the assistance of the family law screening officer to determine whether a JCC should be required. I see that one of those family screening officers is here with us today, Brendan Prokopchuk, and he will be happy when November 1st comes and he's sprung into action. If the judge is not satisfied that the prerequisites have been met, the judge may refuse to schedule a JCC and will direct the requesting party on the further steps that need be taken. If the judge is satisfied that a JCC should be scheduled, the court will provide the requesting party with a notice of JCC identifying the date and the time of the JCC. The requesting party must then serve a copy of that notice on the opposing party. Step 3, 2 days before the JCC, each party must serve and file a judicial case conference appearance memorandum. Step 4, a JCC will take place in an open courtroom on a Thursday afternoon or a Friday morning or Friday afternoon. Multiple JCCs will be scheduled at that time. Typically, a lawyer can attend a JCC on behalf of a party unless the judge requires the party to be personally present. During the JCC, the presiding judge may make a procedural order, such as requiring parties to exchange relevant financial information by a certain date. The presiding judge may also make a substantive order with the consent of the parties, schedule another JCC, set a date and time for a summary judgment application, direct a pretrial conference, or set the matter down for trial. Further, the JCC judge may set a date and time for the Chambers hearing. To ensure that the Chambers hearing proceeds in an efficient manner, the judge may also make an order identifying the issues in dispute, setting filing deadlines, providing direction on the materials to be filed, and setting time limits for oral argument. It will be more than likely that matters set for Chambers will be more focused, the material will be in order, and that it will be set to a date and time when the application can be conveniently heard. So, what are the objectives and benefits? First, we believe the process will decrease conflict and increase resolution. Second, we believe that the process will increase access to justice for self-represented litigants as well as for represented parties. Third, we believe the process minimizes the risk of litigation abuse and misuse. Fourth, we believe the process will reduce cost and time to obtain procedural orders. And fifth, we believe the process will reduce the cost and time to obtain substantive orders. To conclude, the court is excited to implement this innovative project. I am of the view that the JCC process will greatly improve how family justice is delivered in Saskatchewan, and I'm eager to see how the project will be expanded in the future. Thank you very much.
Thank you, Chief Justice. A couple things. My somewhat entertaining comment is we were talking beforehand about how long our presentations would be, and the Chief Justice said, mine will be about 12 minutes. Well, just for curiosity, I timed him. He was 12 minutes and 33 seconds. And the other one would be just being involved in the family justice area with the Ministry of Justice. I would say that the Chief Justice and his judges have been leading a paradigm shift, not just on this, but on a number of other things in the Court of King's Bench. So I'm sure there'll be lots of questions on that. So thank you very much for that. Tiffany Paulsen, please.
Thanks, Lionel. My name is Tiffany Paulsen. I'm a partner at Robertson Stromberg. And my practice focuses almost exclusively in the area of family law. First, I want to thank the College of Law for putting this series on. I always think it's interesting when we have an ability to come in and speak directly to the students. And also thank you to McKercher for your generous support in the lecture series. So I'm speaking on one aspect in particular, which is legal coaching and unbundled services from sort of a in the trenches perspective from a lawyer who is practicing in the area of family law. I would say 10 years ago, at least 90% of my practice was litigation driven and focused. And with all of the new initiatives, if anybody sends me an email, you'll now see that I'm a mediator, an arbitrator, parenting coordinator, collaborative lawyer. And so I would say more than half of my practice now is driven by alternative dispute resolution. I am still a trial lawyer. You will see me regularly appear in chambers in court, but I would say the majority of my practice area right now is really focused on alternate dispute resolution. And primarily because I have a personal interest in that as well. I just, having practiced law for 24 years, from that experience, it is better for families, from my perspective, to be resolving their matters outside of a courtroom where there's a third party, a judge who has never really met them or their children, making decisions about the most important aspects of their lives, which is their children. And there are a lot of separate and apart from new or novel fact patterns, which I know we often focus on in law school. On the average, I would say, Canadian or Saskatchewan family, there are some truisms in 2022. If you have an average Canadian family, for example, living in Saskatoon, it's likely that they're going to share the parenting of their children in this day and age. It's likely that child support is going to be viewed on some type of set-off formula in consideration of their incomes. They're going to divide their property 50-50. Nobody's going to be allowed to move in the middle of litigation away with their children. So those, and again, those are sort of average truisms that I would say are correct in family law. So there's not a need for folks to litigate that in this day and age, frankly. I think there is, despite the fact litigation lawyers always tell their clients that litigation is risky and uncertain, there are some general truisms I would suggest at play in the law. So what is legal coaching or unbundled services? Lawyers, when they are involved in files, family law files from start to finish, the costs can easily range in the tens of thousands to the hundreds of thousands of dollars. So unbundled services is where lawyers manage certain parts of the files and the clients actually represent themselves in others. And limited scope legal services, the fancy term for what I'm talking about, is really, it's an approach to delivering legal services where the client and the lawyer break down the client's legal matter into a series of tasks that need to be done, and the lawyer provides legal services for a portion of those tasks. And within the limited scope model, the lawyer or the client actually accepts responsibility for performing one list of tasks, and the lawyer accepts responsibility for that other discrete list of tasks. And so, you know, examples would be a client's off to a pretrial, so they might file the brief, but they want a lawyer present during the pretrial to help them with the negotiations. Or clients are off to court, the lawyer prepares the materials for court, but the client actually goes to court themselves to tell the judge what they're looking for. So that's what I would say unbundled. And then legal coaching, which is typically where the lawyer does not appear in court or on the file at all, or what we call on the record. They assist the client in the background, putting together written materials, helping putting evidence together for trial, gathering evidence, and essentially in the background, the lawyer is assisting clients with strategies and tools to present their case as effectively as possible. And while sometimes when I've spoken on this before, people are like, ooh, that's a new concept, that's very interesting. I would suggest that this is actually not a new concept. For most, I would say particularly for family law lawyers, we've been doing this all along, just not in a formal, fancy, limited scope legal services title attached to it. Very common examples, clients come in, they've recently separated, they need a support order in place. I may bring that application to Chambers, get that in place for them, and then for financial reasons, they continue on with the rest of their litigation on their own, representing themselves. Or matters have been settled, clients just need a divorce, and they need some assistance with that. And so I think this unbundled legal services has been happening all along. It's just now we have, I guess, more formal arrangements. I'm not going to get into this, but there are certain rules for lawyers providing unbundled services about filing letters with the court and things like that, so that the judges are aware of what the lawyer's scope is. Because, for example, there's a rule of court, when you go to a pretrial, you're the lawyer for trial. So unless the pretrial judge is aware that you're there on a limited scope, you're automatically going to go on the record for trial. And so we, now that the Law Society and other folks have become involved, there's some sets of rules that lawyers providing unbundled services need to provide. So the question is, why would a lawyer do this? And I mean, the straightforward answer is people can't afford lawyers. That's it. There's no magic to that. At $500, $600, $700 an hour, it's just you got folks facing very real legal issues and challenges that can't be ignored, but they just cannot afford the cost of a private practice lawyer. And because when I was getting ready for this, I have to admit, a bit of a data nerd, and probably a big data nerd. But and you may think, well, geez, like, how big of a deal is this? Like, how many people really need private practice lawyers anyways? But the reality is there are over 815,000 adults over the age of 20 living in Saskatchewan right now. And 48.4% of those adults will experience one legal problem over any given 3-year period. So that's significant. That's almost half. Now, I will say legal problem is broadly defined, because even I was taken aback by that statistic. I'm like, really? Like, 48% of the population is off to criminal court? Like, that's where my mind went. But I'm like, wow, I've sort of misread society, actually, when I saw this. But really, the data uses the term legal problem, but I would say legal issue, because that would include someone buying a house, or someone needing a will, or somebody with family law matters. It doesn't mean they're engaged in the criminal justice system. So, but when you look at 48.4% of the adult population needing legal services, and the average income in Canada is $56,000 right now, these people cannot afford to be paying someone like me $500, $600, $700 an hour to manage their legal issues. So we need different alternative answers. And so that's when, I guess, the need for limited or unbundled or coaching services becomes really apparent, because clients need information. That's mostly what they need at the outset and throughout their sort of legal career, I guess. And sometimes the information they need is very straightforward. It's just, Google can only help you so much. The law is complicated. And they need and straightforward information. Like if you're a parent family law context, you need to provide your income information to the other side. Like don't fight about that. Don't go to court about that. Like you have to provide this type of information. If you're a joint decision maker, you get a copy of your child's report card. You get to go talk to their doctor about their medical issues. This is not something to fight about in court. These are rights and responsibilities that all parents have. So why not just pay a lawyer, even just for an hour of some very straightforward legal advice that will save you, it may cost you $500, but it's going to save you $10,000 in a court application. So why not get the information up front? But sometimes, though, things aren't straightforward, and there are significant legal issues to be addressed, whether it's in a family law context or an immigration context or human rights, employment issues. And those folks have very real legal issues, but they still cannot afford to pay the type of hourly rates that lawyers are typically charging. And so that's when the coaching or the unbundled services can be of true value for some clients. And, from a lawyer's perspective, and as, many of you are about to start your legal careers in the next couple of years, you might say, well, why would I do that? Like, why would I offer unbundled services? And, from a purely practical perspective, I'll just speak as someone who's practicing law, it really makes no difference to me whether I'm spending my time getting ready for chambers, putting together materials for a client who wants to, whether I'm representing them or they're representing themselves in court. I mean, the same rates still get, charged or applied. And so, but to me, if you're working in a capacity that's going to improve access to justice, then as a lawyer, from my perspective, you really feel that the work you're doing is making a more meaningful contribution. And from a client's perspective, the data is there. Bree has spoken about this and has this kind of data. They feel more empowered and in control of their situation. They have more information about the law and what's required of them. And there's practical outcomes, really. Lawyers, I view, have a true responsibility. My colleagues across the board may not agree, but I feel that lawyers have a responsibility to shut down those unnecessary court proceedings by providing appropriate legal information to clients. And I truly believe they have an obligation to do so. And from a legal coaching perspective, when, people fly into my office in a, mass outrage that, about amounts of child support they're being asked to pay. And, they've basically dared their co-parent to take them to court, see you in court. And, I say to them, you have to pay child support. Like, that's not a debatable issue here. Like, let's just get your pay stub and not go to court. Like, and just, they're sort of like, oh, okay. But, when they hear you have to pay child support from their ex-spouse, it drives them mental. If they hear it from me, who's a sort of a dispassionate, uninvolved third party, I'm like, that's what the law is. They sort of like, oh, okay, well, then maybe we shouldn't, go see a judge who's going to tell them the exact same thing. And you see court proceedings averted at that point, which I really think is a true responsibility of lawyers. Another answer to the question of why do this has been found in some of the research. I said Bree has brought that forward, and Bree's group and Sarah's group, and they all these folks all deserve, I know you guys are like, oh, they're just my profs and blah, 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 but they deserve a lot of admiration, respect for the work they've been doing on this access to justice discussion. They're focused, and I would suggest militant on the discussion, but producing concrete outcomes. We need folks like them who are pushing the legal community, in particular the private practice community, to embrace these alternative service delivery models. So make sure you give these folks a pat on the back the next time you see them. And so it's some of the research that I've seen from Bree's group. One of the reasons that clients embrace unbundled services is they actually, they feel confident going in that they can represent themselves in court. Now, I have to admit, I actually kind of smiled when I saw that because I know that there are folks out there that feel that a couple of episodes of Suits will, it's basically the same as a law degree. And I've seen that situation play out in court with unrepresented folks. And, for those of you who are in law school and wondering, maybe you made a bad choice, and that maybe Harvey Specter is professor enough for you, I would encourage all of you to stay in school as I see these self-reps roll themselves out. But it's a different story when they come, and Chief Justice Popescul could speak more directly to this, but it's a different story when you have someone standing in front of you on, for example, an issue of child support who has never spoken to a lawyer, and one party's like is saying, I want child support, and the other party, there's no income information before the court. It's impossible for a judge to make a decision. So at least if there's some coaching in the background, and you say to these folks, take your income information, take your tax returns, take your pay stub, give it to the other side in advance. This is not, we don't practice in the area of surprise law anymore. You all provide all of that, then real decisions and practical decisions can start to be made at that point in time. So I guess in conclusion, I would like to encourage all of you as future lawyers, where I believe lawyers need to do a better job when it comes to unbundled or coaching, and this includes me and my office, is really making sure that clients understand these services are available to them through your private practice. People have a real fear of contacting lawyers. They're scared that if they phone me, a $10,000 bill is going to materialize in their email box 3 days later. And that's, there is true fear about that. And these are folks who are trying to do the best for their children, trying to manage their day-to-day lives, get their electrical bill paid, get their mortgage paid, and they're trying to do the best for their children. And so they are paralyzed in fear that one small call to me is going to push their financial situation into pure chaos. And so I think for me, I would encourage all of you to consider and think about providing unbundled or coaching services, and for wherever practice you end up in, encourage your group to make sure that information is available on your firm website. Make sure that you are talking about providing those types of services, because lawyers, I really believe, could do better about helping people understand that there are lots of private practice lawyers willing to provide legal services in a more manageable way. And those would be my comments. Thank you.
Thanks, Tiffany. Very positive message. I'm with the Family Justice Service Branch, and when you change legislation, we look at studies. We do, like the Chief Justice talk, we go look at other jurisdictions and see what they're doing and then model it for here. We also talk to clients and lawyers. We have a number of lawyers that work for justice that specialize in the family law area, and most of them would say, if Tiffany tells you something, listen, because it's a positive thing and it will turn out well. Not that it always works, but she's certainly well respected for our family law lawyers, so thank you for that. So, Stacy.
Well, this is fun. I haven't been in person with people in about 3 years, so forgive me. I'm used to Zoom presentations and all that kind of good stuff. This is actually the first time in about 3 years since I've been back to the Law College. I have a little PTSD about the Law College, but that's okay. I'm Stacy Muller. I'm the director at the Dispute Resolution Office. My office is out of Regina, but we have offices in Saskatoon and a really tiny one in Prince Albert. I was thinking back, and it's been about 10 years since I took Professor Uyghur's class, sitting in this very room. Time flies when you're having fun, but I took Family Law 2 from Professor Uyghur's, Family Law 1 from Greg Whalen, which was an experience. But I know intimately how the law student experience, as particularly at this college, feels, so it hasn't been too far removed. I can tell you hello from the other side. There is life after law school. It can be fantastic. There is a place for you, and there's lots of work coming in, and grab a shovel. We've got lots to do. So my journey to this role, I finished law school here, went to private practice briefly, and then got recruited by the Ministry of Justice to go work in what was then called the Innovation Division. We got to work on fantastic stuff at the beginning of this whole what is access to justice idea. which was new to me, not necessarily to the world, but on innovation and system design and how do we make the justice system better on a pretty broad spectrum, and not surprisingly, family law came up quite a bit. I'm really passionate about family law. It's one of my favorite areas to talk about. I could talk to you all day, but I know I have a limited amount of time, and I know Lionel's probably timing me, so I will be careful. I'm passionate about families because I think that, in essence, they're the fabric of society. A lot of our community is built on the back of family structure, and it's really important to maintain the integrity of that. Even if families aren't intact, the relationships can still be positive, and there is a way to do that. So that's kind of my own personal mandate towards families. And I think that there's some really, just sitting here listening to the presentations, right now, whether you realize it's sitting in law school or not, you're on the cusp of some significant change. I've never seen more change in the family law sphere than over the last 5 years. It's phenomenal. There's great people and stakeholders, the court, private practice, the college, CREATE, the Ministry of Justice. We're no longer reading all of these reports, we're now actioning them, and it's a fantastic time to be entering legal practice. So if you're going to be working in the family sphere, welcome, come on in, call me. There's lots that we can do. All right, so I was called by Bree to come and talk about what's called the Mandatory Family Dispute Resolution Requirement. That's a mouthful. You'll sometimes hear it called MEDR. You'll sometimes hear it called Early Family Dispute Resolution. But basically, family dispute resolution is what's in the Queen's Bench Act, so we'll go with that. Section 4401 of the Queen's Bench Act requires parties in a contested family law dispute who have not already done so to attempt some form of family dispute resolution process before they can continue on through court. So it's a do not pass go. One of the judges will probably ask you that question. Actually, the JCCs and some of our fine folks over there are going to ask you. Family dispute resolution includes the services of fine folks like Tiffany, who are family mediators, arbitrators, parenting coordinators, or collaborative law lawyers. There's a buffet of options, both government and private practice options that people can choose from. Family dispute resolution, in its essence, empowers families to be able to resolve issues outside of court to the greatest extent possible, reduces that financial, emotional impact of separation and divorce to the greatest extent possible. So Bree had asked to put a bit of a focus on this towards data and what have we been measuring, a bit of an evidence-based approach. So looking back on it, I tried to piece it together to kind of show you what's the story of how did we get here and how are we tracking it from here. So I feel like I'm preaching from the same songbook as Diane and all the other speakers, but the same reports in 2013, 2014 that were foundational, the Access to Justice reports, particularly the Cromwell report, the Access to Justice Roadmap for Change, those are cornerstone documents. I took them for granted when they came out right away, but we have relied on those time and time again in crafting our policy and our approaches. The Cromwell report, if you haven't had a chance to read it, which you absolutely should, talks about the need for change in civil and family law systems, and it recommends a step forward. One of the strong recommendations is on family law, specifically to the greatest extent possible, focusing on a robust sector of early resolution services, and that can be a variety of things. There's also reports on how children exposed to protracted and unresolved conflict are more likely to demonstrate internal and external behavior and social adjustment issues, anxiety, depression, those kinds of things. As Tiffany mentioned, a lot of our Saskatchewan citizens are going to interact with the justice system on a family law issue. It's not always, the flashy criminal law stuff. It's often family stuff. So let's gather a little data together. How many people, you can raise your hand, know someone or are related to someone or have personally experienced a family law issue? Yeah. So it's likely going to touch, so there, we just gathered some data in real time, but it's likely going to touch a lot of people throughout their life. So it's less of a discrete legal issue and more of an everyday, maybe not getting divorced every day, but it's a very, I hope not, it's a very common legal issue, what's the word I'm looking for? It's combined legal and non-legal situation that people will experience in their lifetime. It's not an uncommon event anymore, unfortunately. But there's ways to do it well, and there's ways to do it that are very difficult. We know that families are struggling in the justice system. Many of the presenters have touched on that point already. The Legal Services Task Team report that came out in about 2016-17 talked about that family law cases in Saskatchewan require more court involvement than the average civil file. They account for nearly half of the civil court events, including 72% of adjournments and 87% of trial hearings, despite only representing about 37% of the cases that are in the court. So there's a lot of touch point. There's a lot of people wheeling, trying to resolve things. A lot of it is people being unrepresented and struggling. Families are having a hard time. They're having a hard time with the legal issues. They're having a hard time with the stress and the emotional toll that separation and divorce can take, the relationship elements, and they're not often, this comes from my personal experience of talking to people either at our front counter or by phone at the dispute resolution office, but they're not in their most resourceful state. They're struggling, and it's a really hard time for people. It's hard for lawyers too, because it's not always the nicest area to practice. I remember being a baby lawyer at the law firm, running out to get, to serve collection letters or calling people at Christmas, being like, pay your bill. And they're like, I don't have my kids. And you're like, I'm sorry about that, but we need to get paid. So it's not some of the traditional ways that we've been practicing are also hard on lawyers as well. Anyway, all this to say, we've done a lot of consultations, surveys, working group task forces, feedback, town halls on access to justice. We've talked about this a lot. It was time to do something. It's time to make some change. And we have informed ourselves with all of these great reports and also some of the feedback from our own programs. The Dispute Resolution Office has run mandatory civil mediation since 1995. It's had some evaluations. It's seen some success. You can resolve things in that early dispute resolution model. The Family Matters program through the Dispute Resolution Office also, actually we did it in tandem with Lionel's shop too, offers free 3-hour problem-solving sessions and information to people just to try to help them resolve family law issues. One little story from that is we had a family come in, and it was a mom and a dad, and they were struggling to resolve some things. Really, they just needed information and assistance and a self-help kit. They could do it themselves. But they told a story about, it was actually the dad's sister, and in that situation, his sister had spent $80,000 on legal counsel, and they still were not resolved. So what they had said is, we want to do something different. We want our separation and divorce to look different, and I think that we can try to resolve this a different way. So we took some of that anecdotal feedback, people coming to the counter, the phone calls, and we said, let's do something different. How are we going to make the justice system better for families that are experiencing separation and divorce? We focused around some of that culture and paradigm shift that Diane was mentioning in her presentation around separation and divorce, and this one comes from the Family Matters program, but it doesn't have to be a fight. The first thing that you do is not necessarily what you see on TV, which is lawyer up and go to court and put on the boxing gloves. It's you can resolve this, we can help you, you're going to need some information, but there's ways to navigate through this in a way that's less adversarial. You can do it, we can help. So we wanted to change the culture around separation and divorce, improve the experience for families, reduce conflict, increase cooperation and communication, promote efficient use of the justice system, and reduce pressures for courts. How did we build it? How did we generate the ideas that were going to work? We designed with the public in mind. There's design thinking theory, which is citizen-centered design, where you're designing for the person or the client that's actually using the service, not the people that are delivering it. So it's not about Stacy and whether she likes the way that this flows, or about the lawyers or about anybody like that. It's about the citizen. That fits nicely with government because one of our core values is most certainly to serve citizens and to try things, to try innovation and see if we can do things better. We looked, as Lionel said, to other provinces. We tried to make things understandable for people. We did do a little process mapping, but I don't have a big, pretty process map for you. But there was some flowcharts and that kind of thing. We asked a lot of what-if questions just to see how it would flow and whether the legislation would work. We gave some feedback on the legislation, tweaked some things, and then we tried it. Sometimes you have to just try something. And we piloted it in the Prince Albert area on, maybe not the best timing, January 1st, 2020, about 2 months before the pandemic hit. So that was a bit of an impact. It made determining success a bit of a challenge in collecting data for that area to see if it was working or not working. I think everything was impacted. We expanded to the Regina Judicial Center on March 1st, 2021. We got feedback from the public, we did surveys, we talked to service providers, we got feedback from the court. We tried to see how this was working. It looked like it was working particularly well. And we've been tracking, then we went province-wide just this past July. So that's been very exciting. We're seeing a real momentum and more families getting connected, more families doing things earlier before they even file anything at the court. Sometimes even before they contact lawyers, they're saying, I think we can try to resolve this. And so far, we've recognized 134 service providers. So in Saskatchewan, we have 73 mediators, 19 arbitrators, 21 parenting coordinators, 21 collaborative law lawyers. We've had almost 4,000 hits to the Early Family Resolution website in just 2021, 2022, so that was just 1 year. Those are continuing to increase. Over 500 individual contacts to an office we set up to answer questions for the public. And we've received 194 certificates of participation to date. So that means 194 families in our province have already engaged with this requirement, likely more because I need to kick service providers in the butt to send me their certificate. So if you're a service provider, send me your certificate or send it to the Early Family Resolution Office, because that's the only way we're tracking some of this data, just to see how many families are getting connected. Most families seem to like mediation. That seems to be the most common option, but there have been collaborative law processes, and I think maybe one parenting coordination, but I'd have to double check. Early informal feedback from the court indicates that there are, in fact, fewer contested family law applications making their way to court. And even some of the feedback from the judiciary is also that even when parties are going back to court, they are having fewer issues, better communication, and are often better prepared to be able to talk through. And I think that that's going to couple really nicely with the JCC project that's taking place. I think families are going to do really well. The DRO is one service provider, and we found that even when parties are connecting for service and they have the certificate for, like, they've done their part, you've participated, yay, good for you, good gold star, they're still continuing on because they're enjoying the resolution that they're getting. They're actually making progress, and they're starting to see improvement in their relationship with the other party. What else was I going to tell you? A lot of the feedback that we get on this is not necessarily quantitative, data-driven. A lot of it is talking to people. It's talking to the public. It's me walking up to the front counter and asking people how things are going. It's taking feedback in surveys if people will give it to us, and it's talking to other folks that have experienced family law issues. A lot of the feedback we get is, oh, that makes sense. I don't know why they didn't do that sooner. Or, I wish this was around when I got my divorce. Or the one that kind of breaks my heart, but I can see it, but is, I wish my parents knew about this when they were getting divorced, because things could have looked a little different. And so, overwhelmingly, I'm not finding that there's a lot of resistance to this. It's a welcoming in of, it's time to do something different, and we're excited about what this is going to look like. Because we just expanded province-wide in July, give me some time to get you some more data on how it's working. So far, it's working really well. Our approach is progress over perfection. We will make iterative changes as we go to the greatest extent possible. We welcome feedback from everybody, and we'll continue to build on different successes and share and collaborate. I am so proud to work in a justice system with folks that are focused on family and focused on doing things differently. And I think that if you're going to continue and stick around in this province, that's a really good thing. We're going to do some good work together. So, yeah, thank you.
Thanks, Stacy. We are going to quickly try to get to some questions here. So Bree and I are going to work on that. Questions can be emailed to createjustice@usask.ca. So createjustice@usask.ca. And Bree has a mic, so anybody has questions, now would be the time. There we go. Question.
Hi. As you probably know, Saskatchewan has, I think, the highest rate of police-reported family violence in Canada of all provinces. So family violence is a real issue in this province, and I haven't heard it addressed in any of the presentations this afternoon, and so I'm wondering if you could address it and how it's being dealt with in light of these new processes.
Brecken, we've got help here. You want to, Brecken, the screening officers from the Chief Justice can speak, or the screening officer can speak, but.
What I'll just say is that in the 12 minutes that I had, I wasn't able to touch on that, but family violence is an integral part of the JCC process.
Yeah, that's their core goal, is to screen, and I know some of this from the outside, is to screen on the front end for family violence. So.
Myself and my counterpart in Regina wear two hats. Something we're doing is the files that are coming in, we're doing family violence screening as part of the JCC process as well as outside of it. Our role is to make sure that anybody who does bring up family violence at part of their court process, we're working alongside family services, various shelters, organizations available throughout the province to make sure people are provided the resources that they need in relation to the family violence side, not just about how to deal with their court matter.
Good question. Oh, we have a question. Diana.
Not a question as much as an answer. In Alberta, we have been doing a lot of work with the domestic violence sector, and our work is really around prevention, trying to understand through brain science why people use violence and to change our responses away from a binary punishment and safety kind of approach to one that is about ensuring that there's healing for both people who use violence and people who experience violence. It's still early stages, but part of what we're also beginning to explore is that the courts in Alberta are involved in a pilot in criminal justice matters that is a restorative justice pilot, and the RFJS has been asked to explore the possibility of using restorative justice approaches in domestic violence cases where there's been some hesitation to do that. It aligns perfectly with the largely restorative approach that we're using within the RFJS in family matters, and there's a great deal of interest in our Indigenous communities as well as in the domestic violence sector to find ways to be very preventive because this is just a massive issue that has only been made worse through the period of COVID.
That's an excellent question. Speaking from the mandatory family dispute resolution side, interpersonal violence was something we took very seriously in the design of this. Every service provider that gets recognized has to meet a specific criteria, and one of that criteria is that they have taken training in domestic violence or interpersonal violence. A lot of folks really like the PATHS training, provincial transition houses, and that's been a really good one for people to take. I think that the requirement is, I don't want to misquote it, but it's 14 or 15 hours of that. It's 14, thank you. And in addition to ongoing training, CPD and that kind of thing, as well as encouraging every service provider to be using some form of screening tool. They can select what they like, particularly in mediation. At least I can speak for my mediators. We use the MASIC, but there's other forms of screening tools that should be done at the intake of every file so that you know what type of situation you might be dealing with. I should say that interpersonal violence isn't always a bar to participating in family dispute resolution, but you need to do it safely and in a way that that balances some of the dynamics on that file. And with the benefits of Zoom and that kind of thing, there's quite a bit that you can do to navigate that, but it's absolutely something that should be considered.
Thank you. Any other questions? Do you have a question? We have a question.
Thanks, guys, for today. I'm curious about the downstream effects of some of these programs, knowing that we still have the adversarial system that clients might be making their way through. Is there any data or evidence around how what they might do in the new initiatives are streamlining or helping when they get, if they are not successful at the beginning, or is there evidence of the opposite where it's now prolonging the process? I'd like to frame this in the positive, but it might have come out a little bit negative there.
And maybe I can start off. Tiffany, get the mic to Tiffany, is if family, we're talking about family, so we already won the parent education program. So if you're going to court to fight over and there's children involved, mandatory parent education, you start with that. You have to do that, and then the other processes. But we also have run a high conflict parent education program that the judges order people to. People can go there voluntarily, but it's mainly judges ordering them to go there. They're seeing them in court a number of times and saying, we've got programmed, and there's no guarantees on these, and a lot of people will need the court system to resolve their issues. That's just how life works. We're trying to keep out as many as we can, but there's certainly some that'll end. But that's another way the tool the judges have is to send them to mandatory parent education, high conflict mandatory parent education. Tiffany.
It's a good question, and you're right. We're trying to keep things on the positive, but are there pitfalls to this system? Yes. And so, for example, mandatory mediation just became mandatory in Saskatoon on July 1st. So we haven't had the ability to, from a data perspective, look at the impact. But practically speaking, out in the sort of the trenches where I am, are people using mandatory mediation as a way to avoid paying support and delay proceedings, torment in situations of interpersonal violence their spouse as a means of control? Yes, we see that, 90 days into mandatory mediation in Saskatoon, 100%. So I guess my hope is that as this becomes part of our norm, that these sort of ways of, weaving around some of these mandatory requirements, we're going to be able to plug those holes. It's a question of experience and working through the system, but with all things, yes, are people playing that? Are lawyers playing that? Yes, it's happening, and it's just, I will say though, of the few applications out of Saskatoon, you can apply for an exemption to mediation, and there's a couple of reported decisions out of Saskatoon that are great because the answer is a hard no. And so, and I'm hoping, as the judiciary takes a pretty firm stance on you have to go, you have to do these things, this exemption is going to truly be viewed as an extraordinary circumstance that people are just going to sort of start to deal with what's given to them. The Chief Justice could speak to this better than I can, but I do know prior to even my time practicing law, when they implemented the pretrial system and everybody thought it was a complete crisis and the sky was going to fall in and how could we possibly have a collaborative discussion before trial. I mean, I love pretrials. All lawyers love pretrials because it's a way of having a productive discussion, and I'm hopeful that these initiatives will turn into that as well.
Does that answer that question? And family law is ugly. I remember 30 years ago when I was younger, I was dealing with a gentleman, and we also collect maintenance enforcement, and his payments had just gone up $200 a month because their child had asthma, and he was yelling at me at the top of his lungs saying, I shouldn't have to pay the extra $200 because the asthma came from her side of the family. So we're not going to solve them all. Any other questions? Thank you. Okay, I'll just wrap up here. Thanks to Bree. Thanks to all the people that work with you, Bree, and put this all together. The participants, the ones I can see, the ones I can't see. McKercher LLP, thank you. This is wonderful sponsoring this. And a special thank you to our panel members who brought excellent stories and helped us through all this, because everyone gives of their time, and we appreciate it all. So thank you. And do you want to say anything, Bree, just to wrap up? Perfect.
I'm going to close off with also thanking Lionel very much and for making the trip from Regina to both of our panelists from out of town. And special shout out to Diana for joining us as well. The key objective of our annual Saskatchewan Access to Justice Week is to highlight existing and new initiatives in the justice sector, as well as invite new voices to the conversation. And so I think our panelists did an excellent job today at highlighting some of the new things going on in Saskatchewan, looking to improve access to justice for residents in our province. And it was nice to have a new voice to some of us. So thank you, Diana, as well. And thanks to everyone that tuned in online. So check out the rest of the Access to Justice Week initiatives by visiting our law school website, so law.usask.ca/createjustice. There's a range of other events happening this week online and in person, so I encourage you to do that as well. Thanks everyone for coming.